All right, we'll go ahead and have a panel change now, and I'll take up the next case of Silvi versus Watson Realty.
Sandy Dallenberg passed away.
What's that?
Sandy Dallenberg passed away. He had been ill.
How old was he?
Not that old.
Oh, really?
That's all right, take your time, take your time.
You bring all this stuff so you won't need it.
Yeah, you never have time to look at anything.
Thank you, Your Honor.
I just want to make sure, is this the Silva case?
Yes.
Okay, so they changed the order? I want to be sure.
You change the order.
All right, good morning. We have case number 18275, Silvi versus Watson Realty and Missy Dekay. Each side will get 20 minutes. The appellant, whenever you're ready, if you'll just let me know how much time you'd like in rebuttal.
5 minutes.
All right, I'll set the clock, and just whenever you're ready, you can take the podium and begin. I'll start the time when you start your argument.
Yeah, the second oral argument that you saw on the docket was dispensed with. So that's why you moved up.
May it please the court, my name is Terry Bork, and I represent the appellants in this case, the Silvias. I would request 5 minutes for rebuttal time. And this is a Johnson versus Davis case, and to briefly recite the facts.
Yeah, we're familiar with the facts of the case.
Excuse me?
We're familiar with the facts of the case.
Okay, good. Then let's move to the 4 arguments that we have that we feel justify reversal in this case. And the first one has to deal with...
The appeal for the sellers are out. So that appeal had been dismissed, correct? So all we're talking about is the agent.
Excuse me?
The sellers the appeal had been dismissed, correct?
Yes, and it's been involuntarily dismissed after the plaintiff and the sellers put on their case. And the trial court then involuntarily dismissed it, similar to a directed verdict in the case. And we claim that was wrong for 4 reasons. The first reason is it was contrary to the presumption of delivery doctrine. Below, we established that the La Raza's broker, Ms. Bechtold, had said that she knew that she had delivered the La Raza.
Counsel, I think Judge Cohen was trying to just confirm that the only appellees here at issue are Watson Realty Corporation and Missy Dekay.
That's correct.
Correct?
Yeah. The Parkers are out of the case now.
Thank you.
So it's just Watson and Ms. Dekay. And
Specifically, we're talking about the knowledge and whether you can impute the knowledge of the defect to the realtors. Is that correct?
we're talking about their knowledge of the patio explanation and the 31-page facts. if I understand, which revealed the settlement defects in the home.
Well, the
And-
presumptive delivery doctrine, you didn't really argue that below, right? So,
Well, it wasn't argued by name, but, there's case law that says that you don't have to use magic words. What you have to just use is the essence of the argument itself. And the Silva's attorney spent a lot of time establishing that Ms. Dekay had delivered the documents Ms. Bechtel had delivered the documents to Ms. Dekay, and the office practices of Watson, which would indicate that if a document was delivered for Ms. Dekay,
wouldn't that
she
go
got
to
it.
your argument that circumstantial evidence?
Well,
That's a separate argument, right?
that would also be an argument that could be one of the arguments of
But
circumstantial evidence.
Well, answer this question.
that
Your argument based on circumstantial evidence, that's a separate argument, right?
Yes.
And wouldn't the argument that you just said, wouldn't that go to the circumstantial argument? Circumstantial evidence argument?
Well, if you apply the presumption of delivery, then we believe that conclusively establishes
No.
that under Johnson versus Davis, you
No,
have.
no, counsel, we're missing each other. Presumption of delivery and your circumstantial evidence argument are two separate arguments, correct?
That's correct.
What you just said about, well, we preserved the presumptive delivery because we talked about the fact that it was delivered and the office procedures, wouldn't that argument relate to your circumstantial evidence argument?
Yes, it would also
Yes.
relate to the circumstantial
So
evidence
it would
argument.
relate
That's
to the
correct.
circumstantial, so why would the trial court then jump to the conclusion that you were arguing presumptive delivery when you never actually said presumptive delivery?
Well, your argument, Your Honor, we would argue that that was the essence of the argument that was presented to the court below. But you are correct that it's also an argument that could
It's also
be
the
used
essence
as
of the
part
circumstantial evidence. It's
Yes.
also the essence of that argument, right?
Yes,
Okay.
it also could be used in that. Also, in the second argument is that there was implied actual knowledge that the defendants had in this case. And the SAP case in the Florida Supreme Court says that implied actual knowledge is inferred from fact, and it is that under that doctrine, a party does not have the right to shut their eyes and ears to avoid information and to remain willfully ignorant of
Has
a
any
thing
Florida
that is readily
case-
ascertainable.
Has any Florida case expressly applied the implied actual knowledge doctrine to a Johnson v. Davis claim?
There's no case that we are aware of that has applied it to Johnson versus Davis. That is correct. But we have 6 cases that have applied it in other circumstances, and we filed a notice of supplemental authority indicating that the doctrine has just been applied by the 3rd DCA in December of 2018. And it's not such a outlandish belief that this should be applied in the Johnson versus Davis case. I mean, after all, we have a situation here where documents were delivered to Ms. Dekay. This is what Ms. Bechtel says. They were found in Watson's
Well,
files.
hold on.
They actually had the
Were they,
documents. So-
that's not the way I read the transcript. The nature of the delivery, the details of the delivery weren't very clear in the testimony, right?
we don't know how they were delivered.
You don't know if it was delivered to Ms. Dekay or if it was delivered
Ms.
to...
Dekay specifically said that she knew that she had delivered them pre-closing. That was her precise testimony. She knew that she had delivered them. She couldn't recall that she...
Delivered them to, she didn't say to Ms. Dekay.
She delivered them to Watson's office. That's where she delivered them. And they were found in Watson's file.
And I was just correcting you because a minute ago you said that they were...
Excuse me?
I was just correcting you because a minute ago you said
that's
they were
right.
delivered to Ms. Dekay.
So under that theory, you know, the documents were there, they were readily ascertainable, and they should have been reviewed by Ms. Dekay.
Counsel,
And-
let's assume for a moment, it's an interesting argument that to look at the implied actual knowledge doctrine in a Johnson v. Davis case. What is your evidence of willful disregard of the knowledge, right? So in that doctrine, it has to be the person has to willfully not obtain the knowledge as opposed to, I suppose, negligently.
That is correct.
What's your
You
evidence
have
here
to-
that was willful?
You have to have knowledge, as Judge Posner said, to the point where it looks like you do not want to look at it, you do not want to receive it. And our documents, the main follow-up to that would be willful, is the fact that these documents were produced because Ms. Dekay had asked for a clarification of the seller's disclosure statement, which had revealed that there were settlement problems on the property. Now, if she had never gotten those documents, the question arises, why didn't she ask Ms. Bechtel to clarify those questions? Because that question would have never been clarified. Now, she tried to claim well, some other documents I received.
Counsel, you're talking about clarification of the disclosures?
Yeah, the clarification of the seller's
5 and
disclosure.
12?
Huh?
5 and 12?
Yeah.
I don't follow your argument. Why is it suspicious that Ms. Dekay would ask for clarification of the 2 questions on the disclosure?
Well, it was Ms. Dekay who said, we have this discrepancy in the answer here. We have an answer to 5B that says, yes, there were settlement problems, and 12B says, well, there are no problems with foundations and walls, and she asked for
Right, but
an explanation.
Okay, but why is that suspicious? You sort of seem to suggest that that is suspicious and somehow establishes the implied actual knowledge doctrine. I'm just not
Because
following
the
it.
only thing that answers that clarification would be the documents that Ms. Dekay said she delivered to, that Ms. Bechtel said she delivered to Ms. Dekay. The La Raza explanation and the 31-page facts. Otherwise, she has an unanswered question out there, and a real estate broker would have said, hey, you never answered my question. And my question is, what's this problem with settlement? Obviously, she had to receive those documents and review them, and she realized that those answered the question, but not in a way that she wanted. Or she received the documents and maybe for some reason just blew off reading them. But if she did that, the information was readily ascertainable, right in front of her, and she could not have ignored it. And what's significant there is during trial, she tried to say some other documents provided that clarification. But when asked specifically what the other documents provided the clarification, she said, I don't know if I can specifically identify the language in the other documents that provided that clarification. And this gave me the explanation of it. That's all I can tell you. I have no other recollection in how my mind worked. And we would
Yeah, it just seems like she was saying that years and years before, she can't remember everything that happened. That's what I took when I read the
Oh,
transcript.
yeah, it was 11 years ago, but she still had the documents in front of her that day. She had the Lazarus.
No. But it seemed like she was simply saying, look, I can't recall why we felt like our questions were answered. Not that, oh yeah, these documents were what answered it definitively, and only these documents. I didn't read it that way.
Well,
Am I
we would
missing
ask
something?
the court to take a look at those 2 documents. It's the Lazarus, I think it's a balcony explanation, and the NED letter, and you look at that, and you see they discuss nothing about settlement. If someone looks at those documents and say, that answered my question on settlement, no, they didn't. And that's the reason why she couldn't point to specific language in the documents. Remember, it was 11 years ago, but she had those documents present before her. She could point to and say, that's the language that discussed settlement, and she could not do it because those 2 documents did not answer that. So she has this question that she asked for clarification of settlement, and she never got an answer to it, she says. That's what would have to be concluded. But we think that the better conclusion, and the one that the trial court should make, would be, hey, you did get these documents. They disclosed the settlement problems, and you decided for some reason not to show them to the Parkers and not to show it to the sale years down the road to my clients, the Silvas.
I struggle a little bit with the concept in that you've got a lawsuit against the sellers who are in the best position to be aware of the defects. Their case gets involuntarily dismissed. you appeal and you drop that appeal, but yet go forward on the real estate agent?
I'm not sure I understand the question. If you're asked, I have a little problem hearing, I apologize. But we reached a settlement with the Parkers, so they're no longer a case. But the case law is quite clear that under Johnson versus Davis, that disclosure obligation still applies to the real estate broker. And I want to go back to the clarification question for just an instance of saying, you know, we have here a motion for involuntary dismissal. In granting a motion for involuntary dismissal, a trial court cannot weigh the evidence or make credibility determinations. Essentially, here we have a credibility determination that has to be made regarding Ms. Dekay's testimony. And we feel that it's a pretty easy one if you take a look at the documents that she says answered, you know, clarified the settlement issue. Those documents do not discuss settlement. They could not have provided the answer. And her statement that regarding the 31-page facts and the La Raza explanation, she can't recall if she reviewed those documents. She doesn't deny reviewing them. She just says, I can't recall reviewing those documents. Well, we think that we have enough to have gotten to a trial court decision on the merits. And this case should not have been resolved through involuntary dismissal.
Does your evidence by necessity rely upon the fact that the documents were in the file of Watson Realty to impute knowledge to the agent?
Well, it wouldn't be the first time that someone has lied on the stand. That might be the case. It might be the case that someone just forgot that these documents came in and she had a bundle of work and thus she didn't do her due diligence and actually look at the documents and later on realize, boy, I'm in a problem here. But that contention is, you know, made in trial courts every day and is entitled to a fact finder to decide it.
But you have the burden of showing actual knowledge, which is you know, sometimes a difficult thing to prove, correct?
I don't see anything that requires actual malice to be showed. What we have to show is that there's
knowledge, not malice, actual knowledge.
Yes, we have to show actual knowledge.
Right,
and we show actual knowledge through the doctrine of implied actual knowledge. And we should note, we would like to note that it's very dangerous.
But does that all presume knowledge from the fact that the documents were in Watson's file, in a closed file in their office?
That'd be the knowledge from the documents from the La Raza explanation and the 31-page facts, and even from subsequent documents that were readily ascertainable if Ms. Dekay had just called up Foundation Systems and said, give me these other documents, which, by the way, she testified she would have done if she had recalled reviewing the facts, and the Parkers said they would have demanded if they had received these documents.
Counsel, you're into your 5-minute rebuttal. You can keep going if you'd like, but...
No, I'll stop here. Thank you very much, John.
May it please the court. My name is Michael Orr, and along with John Leonard, I represent Missy Dekay and Watson Realty, who asked that this court affirm the trial court's involuntary dismissal of the Silvi's claims pursuant to Rule 1.420. Judge Cohen, you asked the question about the sellers not being here. The record will reflect the sellers filed a motion for attorney's fees and costs. My client did not. They were dismissed, and they are not part of this appeal at this point. Your Honors, the problem with this appeal is embodied on page 1 of the reply brief. On page 1 of the reply brief, in the third paragraph, the Silvi's state to this court that the 31-page facts, the lower deck explanation, and the Magnano report all reflect issues that lead to unsuccessful repairs. There's no evidence anywhere in the record that the repairs that were conducted.
I don't agree with that. I think that there is evidence in this record to show unsuccessful remediation attempts, and that the sellers were aware of it. The question is, do we get to the point where the real estate agent is deemed to have knowledge of it. And the question is the fact that those documents were within their files in Watson Realty, is that sufficient to at least get past a direct, an involuntary dismissal?
I'm going to address both points Your Honor raised. First, as it relates to Ms. Froman, previously Ms. Bechtold providing the documents. The documents that were found in the Watson file, Ms. Froman did not have an email, a fax, a letter, and had no indication of when she may have provided it to Watson or how it got there. She just knew that she would have given it to them.
Well, she said before closing.
She thought so, but she could not remember when and what date, Your Honor. That was her recollection of when she thought she may have done it. But
you're not taking a position that that information was not sufficient to bring notice as far as the problems with the property. It's just how they got to the file and when they got to the file. Is that correct?
That's correct, Judge. And I want to go back to Judge Cohen's point. I strongly disagree with Your Honor that there's evidence of repairs that were...
Foundation Systems fax shows, I think clearly shows unsuccessful remediation efforts. I don't know how you read it any other way.
Yes, Your Honor. May I? In 1996, this home was being lived in by Mr. Lazara, Rocco Lazara. And as he was living in the home initially and looking to purchase the home, this is around the time of original construction, he noticed an issue and he went to a licensed general contractor, Benchmark, and he went to licensed engineers. They looked at the problem, and what that 31-page fax reflects is that in April of 1996, Aegis, a geotechnical company, did a report and said there is some settlement movement and we suggest repairing and fixing that by putting in concrete grouting. Foundation Systems, a licensed general contractor or licensed contractor that does that type of work in Jacksonville, in May of 1996, performed those very repairs. My point to Your Honor, Judge Cohen, is nowhere in the record is there a reflection that those repairs that were done in 1996 failed at any point prior to the sale in 2012, and that, under Slytor and Spitali and Carter, is the issue.
Well, I think that the Foundation Systems fax showed unsuccessful remediation efforts as of September of 2000.
Your Honor,
That's how I read it. You can, if you disagree, that's fine. And then in December of 2004, the home's inspected and there are serious cracks at that point in time. It seems apparent from this record that the repairs were unsuccessful.
no, respectfully, Your Honor, the serious cracks, there weren't serious cracks found in 2004, and the lower deck explanation provided by Mr. Larissa in 2004 specifically states, and I believe it's on page 8298 of the record, that he did not experience any settlement after the repairs were done and had not since the entire time he lived in the home. Mr. Larissa then came to trial and testified the exact same way, that during the entire time he lived at the home after the repairs were done, he experienced zero settlement. The Parkers then purchased
Didn't
this
the tile crack twice?
I'm sorry, Your Honor?
The tile on the floor in the home, didn't it crack twice? It was replaced once by the builder, and the builder wouldn't replace it the second time?
I believe so, Your Honor, early on in the 90s,
Were
before
those
those
before
repairs.
the repairs?
They were, Your Honor.
Did they put grout under the pool deck?
Yes, sir, that was the work that Foundation
The
Systems
entire
did.
thing, including the spa and everything?
No, Your Honor, not
Right.
under the spa.
Not under the spa?
Correct, Your Honor, but Foundation Systems never came out and said this was inadequate. They essentially said monitor it, and that's, Mr. Larissa lived there for several years.
What did they mean when they said due to very soft soils, it's likely that additional compression will occur?
I'm sorry, Your Honor.
What does that statement mean in the facts? Or the AGES report? Due to very soft soils, it's likely that additional compression will occur.
It's a prediction by Foundation Systems back in the 90s that it would occur, that it may likely occur.
That's likely, right? Additional compression will occur.
Yes, Your Honor, except for it never did. And Foundation Systems later in 2004, when providing that fax along with the Aegis report of the repairs that were done, warranted the work, and the work never failed. The repairs never failed. And the Parkers purchased this home in 2005 for nearly $2 million in the face of that information.
Balcony over the poolside area have cracking and leaking in 2002?
Yes, Your Honor, but that's not an issue on appeal. The balcony was thoroughly disclosed, inspected, engineers looked at it, the Silvis knew about that, had people look at it, and the Silvis and Ms. Dekay both relied on one of the best contractors in North Florida, Mr. Morales, to do that work, Your Honor. The issue in this appeal is the Parkers, after purchasing this home for $2 million, approximately $2 million, lived there for 7 years without issue, without settlement. And for 12 years, when you combine the two owners, there was no issue and no settlement. And Florida law, from the 2nd District in Spitali and the 2nd District in Slitor and the Carter case, all of these cases are facts analogous to this case and hold that a seller of real property, and by extension that seller's broker or agent, does not have a responsibility to give a history of construction.
Counsel,
Certainly,
what about, isn't there a letter, a September 2000 letter from Aegis in the fax that says that recurrent settlement has been observed in the spa area?
What's
the significance of that?
That's Mr. Larissa reported that and said that he had cracking but not settlement.
That's not in a September 2000 letter from Aegis?
No, Your Honor, it is, but accompanying that letter, that 31-page fax was Mr. Larissa's explanation of what that was, and Mr. Larissa explained at that time in that document, the lower deck explanation letter, that he had not had any settlement. He had only experienced small cracks, and what he did is he asked Benchmark to put in pavers so that he wouldn't see hairline cracks in his deck.
I mean, Aegis disagreed. Aegis says in their letter, recurrent settlement has been observed in the spa area, right? I mean, am I reading this wrong? September 2000 letter.
No, Your Honor, you're not. But I think it's important to reflect on the fact that that's from the year 2000.
Right.
The sale was in 2012.
Right.
And this was by
But it was after the 1996 repairs.
I don't believe that Aegis ever went back to the property after April of
Okay.
1996,
So
Your
you're
Honor.
saying that they wrote this letter 4 years later and they were just relaying information that they had obtained 4 years earlier?
Your Honor, my understanding is they were relaying information obtained from Mr. Lazara from his statements about the pool deck in 1999 that resulted in the pavers being placed on the deck. Your Honors, if we reviewed the initial brief, what the appellant is essentially asking this court to do is create new law in Florida, and they've laid out 4 issues, and those 4 issues, they can't meet one of them, as it was just suggested, that if the presumption of delivery doctrine is adopted, and by this court for the first time in Johnson v. Davis cases, that they prevail. That only gets them past the first inference, and that was the issue in this case, was the large number of stacking of inferences that, despite Mr. Larissa's express testimony at trial that he had no issues and the repairs were fixed, that he was lying and that the repairs were inadequate. Despite the Parkers' express testimony at trial that they experienced no issue with their kids and their family living at this home for 7 years after paying nearly $2 million for it, that they were essentially lying and that the repairs were inadequate, and that these documents from 12 years ago showing repairs that were done in the 90s were inadequate and should have been disclosed in 2012, and then reflect that in June of 2012 there was a defect that materially affected the value of the home. It's 5 and 6 and 7 inferences, which is exactly what the court in Slitor said court should not do in Johnson v. Davis cases. Other arguments that have been raised, particularly in the reply brief, are again being raised for the first time. Your Honors will see in the reply brief that they're now arguing something called parallel inferences. The Volcker analysis from the Florida Supreme Court is very clear on inference stacking and how those inferences work, and what the trial court did in this particular case. We believe the court should have granted summary judgment on these facts before it even got to trial, but the court gave the plaintiff in this case 3+ days to submit all the evidence that they had and drawing the inferences in their favor stopped the bleeding in this case from continuing and from the defense having to put on more evidence because there was no evidence that they knew of a defect materially affecting the value of the home. That parallel inference argument was never raised below, was never raised in the initial brief. When you get to implied actual knowledge,
You know, you've got, they demuck under the house, but they don't demuck the spa and pool area, and that's really the genesis of all the problems here, correct?
I'm not sure that it is, Your Honor. It's the one area that they didn't demuck, so now here we are on appeal 18, 19 years later, being able to say that.
There is a reason that they demuck property.
Absolutely, Your Honor. This house was built in an area called Marsh Landing. That's the name of the neighborhood. It's literally built on the marsh, and the Silvis, unlike the plaintiff's citation to Osborne and another Northern District or Middle District bankruptcy case, are not people who can't speak English. And
Are you making an analogy along the lines of don't ski down any slope that begins with the word devil?
No, Your Honor, but I am making the analogy that a doctor and his wife from New York who have owned numerous properties and purchased a multi-million-dollar property in a neighborhood called Marsh Landing have the ability and means to perform basic inspections. And they had their own home inspector perform an inspection in this case, and in fact, didn't go through with the sale of the property, and as reflected on page 57 of the record, purchased this property as is for $1.225 million, $700,000 less than what the Parkers had paid for it. In this case, Your Honor, what they are asking this court to do by citing to 17 of their 35 cases from other states and other jurisdictions is adopt new law. This court should decline to do that and should follow Johnson v. Davis and affirm the trial court's decision. Thank you, Your Honors.
All right, thank you, counsel. Counsel, you have, counsel for the appellant, whenever you're ready, you have 4 minutes and 48 seconds remaining.
Your Honors. I would like to start with the argument that they make that the failed repairs worked. They said that it solved the problems. Well, if you look at the foundation documents, the one from April 1996 said that the pile slabs that were going to be used might not work because they might not be able to penetrate the wood at the site, and there might be future sliding.
Yep,
and
might.
then there was a document.
It says might, though, right? It says
Excuse me?
might.
Excuse me?
It uses the word might.
Yeah, it might result in future sliding.
What evidence
and
would
then,
you-
well, let's go to...
Well, why don't you point to that-
Evidence is in
why
the
don't-
next one. It's in
Counsel.
the next document we're going to discuss.
Counsel, why don't you point to, just go to straight to the evidence of
And
settlement
in September
after the
1,
repairs.
2000, there's a document
Counsel,
where...
would
Excuse me?
would you allow the question from the court to be
Okay.
finished before you begin?
All I'm asking you to do is go straight to the evidence of settlement that occurred after the repairs.
In September 2000, Benchmark told Foundation that only a portion of the spa deck had been underpinned, that no pins or grouting had ever been performed under the spa itself. It considered various underpinning and soil stabilization options to address the recurrent settlement problems. However, those repairs were costly, so a decision was made to aesthetically patch the area and to visually monitor the property. A
All right,
conclusion
Counsel-
that the Silvas never were made aware of.
If you could, and that's the letter, it sounds like that's the letter that I was referring to, the 2000 Aegis letter, right, to Benchmark.
Well,
That
I
was-
thought you were referring to the 96 letter.
No, I was referring to a September 2000 letter.
Okay.
Is that the same letter you're just talking
Well,
about?
I discussed two letters. I started with the first one and then went to the 2000.
Okay, great. Thank you. Why don't we move to your argument that while you still have time on the inferences okay? In your reply brief, you seem to argue, or you make a conclusory argument that the inferences are parallel instead of stacking, but I couldn't really make out any analysis as to why you think they're parallel instead of stacking.
Well, they're parallel arguments because you're not stacking one on top of the other to reach a different result.
Well, no, and that's Counsel, that's another conclusory statement. Can you walk me through the inferences and explain why they're parallel instead of stacking?
Well, there's you have an inference from that she knew of the that Dekay's knew of the settlement problems because they had a document, the Lizaria explanation.
Well, you need an inference.
The foundation document.
Counsel, you need an inference that it was that she received it, that Ms. Dekay received it, right? You need that inference. So that's one inference. And then what else do you need?
You have the inference that comes from the foundation documents. You have the inference that comes from the fact that she was aware of the Smith versus Jackson litigation, that there was settlement not 10 doors from the house of the Silvas by Jackson, who developed the very property that the Silvas developed, that she knew that her documents had been subpoenaed in that case, that she knew that she had been subpoenaed as an expert witness in that case, that she knew of the Magnolia report, which 7 months before the sale of this property showed that there were settlement stucco cracks that indicated the history of settlement, and that buyer backed out of the sale because of that. And then all those things she said that she did not recall. But those are all parallel inferences because they're not one inference on top of the other. They're like weighing,
well, your delivery inference, you have
one on top of the other.
You have evidence that you delivered the documents to Watson or Dekay, and it was sort of like one or the other. So there's an inference that that document was put into Dekay's mailbox as opposed to the office file.
It would, but
it could have
follow the office.
Could have gone to either one, right?
That would follow the office inferences that we had here, and it must be noted the danger
But that's
here
an
that
inference.
if they're allowed to escape, then any defendant can avoid a Johnson versus Davis liability by just saying, "I didn't see the document, I don't recall it." And
All right,
therefore,
counsel, you're out of
never
time.
be able to prove actual knowledge, and we would ask the court to reverse.
Thank you, counsel.
Thank you very much, Your Honor.
All right, this court is in recess.